Today's topic is 2 years later, observations from the second year of contested proceedings at the USPTO. All lines have been placed in listen-only mode. If you have a question during the presentation, please submit it via the Q&A chat box. If we do not have a chance to answer your question prior to the end of today's session, we will follow up directly to make sure you receive an answer. As I have already noted in the chat box, if you would like to receive a PDF copy of today's presentation, please send an email request to Carrie Saracini. Today's presenters are Jon Wright and Lori Gordon. At this point, it is my pleasure to turn the call over to Lori.
Good afternoon, everybody. Today's topic, we're going to be talking about a review of recent IPR and CBM P.L.C decisions. And on September 16th of this year, we've officially entered the third year that these proceedings have been available for parties. So we now have 2 years of cases and decisions coming out of the board that's starting to shape how the rules in the statute are being applied. So for the purpose of today's webinar, we'd like to focus on a few hot topics. And what we see here on the slides is a typical timeline of a trial, which you see the pretrial phase, which goes from when the petition is filed through the decision on the petition. And then if the trial is instituted, from that point on, you have the trial timeline, which involves the patent owner response, a motion to amend, the petitioner's reply in any opposition, the patent owner's reply in the case of the motion to amend, followed by oral hearing and final written decision. And between a number of those points, we have discovery timeframes. So since we only have an hour today, we focused on a few of the really hot areas of topics and decisions that have been coming out of the PTAB. The first area relates to statutory filing bars. Then joinder is also a hot topic, and that's closely related to the statutory filing bars, as we'll discuss. Then motions to amend, I think a lot of folks have been trying to figure out how you actually get a motion to amend granted, and Jon will be going into a lot more detail about that. And then everybody's been trying to figure out the boundaries for additional discovery and how depositions are going to play out in these proceedings. So we finally have motions to exclude, and as of, I think, a month or two ago, we had our first live testimony in an oral hearing, which was very interesting, and we'll talk a little bit about that. Okay, so this slide shows the filing statistics for IPRs and CBMs over the past 2 years. And as you can see, there was a bit of a slow start, but as the PTAB started to decide these cases and had some initial high percentage of institution, we saw these become more and more popular to the point of, in June, you see there was 190 filed, and in August, 175. So just over the summer, it equaled, I think, the total amount that the PTAB was expecting per year. So these are very popular proceedings, and we're seeing, I think, about 2,000. These numbers are about a week old, so we're almost at the 2,000 mark for total filings. And just one point, we had our first post-grant review case filed in August, and that was an interesting filing because it wasn't a case that was initially filed after first to file. It's trying to break the priority chain based on continuation claims added after March 16, 2013. So a pretty interesting case to watch. Now, filing by technology tracks pretty closely to what we were seeing in the inter-parties re-exam world. The vast majority of these cases are in the electronic space, and about 14% are in the biotech and chemical space, and that number could be increasing as more and more pharmaceutical companies are seeing the value of these types of cases. We've got 11% in mechanical, and there have been a few design patent IPRs filed in the last 2 years. Okay. So to start off, the statute has a couple bars that are part of the statute. And the first one is the civil action bar. And in this statutory provision, an inter-parties review may not be instituted if before the date on which the petition for review was filed, the petitioner or its real party in interest filed a civil action challenging the validity of a claim of a patent. So as you can imagine, there's a lot of parties that are trying to figure out the bounds of these bars from the statute. So one of the first questions is a counterclaim of validity. A counterclaim challenging validity, is that bar you from doing an IPR? And the statute itself answers that question, and no, that's not a bar. Now, one of the interesting things was what happens in a DJ action. Well, a lot of folks began to file DJ actions of infringement, not of invalidity. So the question was, is a DJ action for infringement a civil action under the statute? And the PTAB, looking closely at the statutory language, said no. So you can file a DJ of infringement or non-infringement and still pursue the validity challenge in front of the PTAB. And you're seeing more and more parties do this strategically. Now, another interesting case from this last year was a party was challenging the is filed language. And as John will talk about in the next bar, the language there includes service. So a party was arguing that by statute, when you see filed, it should be filed and served. But the PTAB said no. So in this case, if you filed a DJ action of invalidity, for example, but never served it, you would still be barred by the statutory provision.
Thanks, Lori. Hi, everyone. This is Jon Wright, and I'll take us through Lori just took us through the civil action bar, and I'll now take us through the Section 315 one-year bar. The language of the statute sounds simple on its face, but we'll talk through a number of scenarios where parties have tested the bounds of that one-year bar. So effectively, the one-year bar says that an inter partes review may not be instituted if the petition requesting the proceeding is filed more than 1 year after the date on which the petitioner is served with a complaint alleging infringement of the patent. So the idea behind the one-year bar is to avoid the scenario that we often saw in inter partes re-exam, where there is a great diversity in the degree to which the underlying enforcement actions in the inter partes re-exam, or ex parte re-exam for that matter, were overlapping, and this is designed to kind of prevent that and get them more on the same track. So interestingly, although the statute, Section 315B, does not refer to a civil action, which on its face would lead one to believe that it extends more broadly to other actions alleging infringement, the board has interpreted Section 315B to only apply to civil actions. And we have the cite to the IPR on the slide there, 2013-00242, paper 98. The board said there that an ITC action does not trigger the statutory one-year bar, nor does a complaint filed as part of an arbitration. So those have yet to be tested on appeal, but that's the board's current understanding, is that Section 315B bar applies only to civil actions. So let's step through some other scenarios that parties have tested and the board has ruled on for interpreting Section 315B. This first slide deals with multiple complaints and cases being terminated or dismissed. So if a first complaint is dismissed without prejudice, that will not trigger the statutory bar. We have a cite to the case for each one of these. If the first complaint, however, is dismissed without prejudice pursuant to a consolidation, so the cases get consolidated in the underlying, if the underlying civil action gets consolidated with another civil action, that will trigger the one-year bar date. And similarly, a first complaint, if it is dismissed with prejudice, that also triggers the statutory bar date. So the key is to look at how the complaint is dismissed to figure out whether it triggers the bar date. Other scenarios include counterclaims, and a party actually tested whether or not the statute operated retroactively. So a counterclaim alleging infringement is a complaint for infringement that starts the one-year clock ticking for a petitioner. An amended complaint, however, does not restart the clock. So once the first complaint is served, your clock starts. It does not restart if you amend the complaint. And finally, the statute bars institution based on complaints served more than a year before the filing of the request, even if the complaint at issue was served before passage of the AIA. That was probably everybody's understanding going into it, but at least one party has tested that proposition, and that, perhaps not surprisingly, is the way that the board ruled. I'll turn it back over to Lori to discuss some institution statistics that we've been tracking.
Okay, so this slide tracks the institution rate for claims over the past year and a half at the PTAB. And what we can see is an interesting decline in the percentage of cases or trials that are getting instituted. And like I said, this is on a challenge claim basis. But at the beginning, the PTAB was instituting trial at a 90% rate, above 90% rate, which I think drew more and more filings into the PTO challenging validity. But since that time, we've seen a marked decline in the institution rate, and it looks like it may be possibly leveling off a little below 80% for institution. And a lot of folks are trying to decide, what's behind this falling institution rate. From my experience, I think what I've seen is that the PTO is starting to be a lot harder on petitioners and demanding that petitioners make their case in full in the petition, and where petitioners have not met that bar, the PTO is more likely to not institute. And I think John has a few more thoughts along those lines as well.
Sure. And it ties into the patent owner preliminary response. The cynical view, I think, is that the falling institution rate is a measure of self-preservation for the board, given the large number of filings. They've hit 2,000, and they're, I think, rightly worried about, being able to deal with the sheer volume of petitions. But one thing that has done from the perspective of a patent owner is brought, I think, an added level of importance to the patent owner preliminary response. Recall that unlike inter partes reexamination, where the central reexam unit would make a decision on whether to institute a reexam based purely on the reexam petition, these inter partes review proceedings allow the patent owner to weigh in on the petition, and then when the board makes its institution decision, it looks at both the petition and the preliminary patent owner response before deciding whether to institute trial. Now, it's an optional filing, but keep in mind that it is the only opportunity for a patent owner to be heard with respect to the institution decision. So in the trial practice guide, as I'm sure you're all aware, there are specific areas that the board points patent owners to that it thinks are appropriate for preliminary patent owner responses. Those include standing issues. The board wants to hear about those if you have them right away. Whether the art teaches away because it perhaps rightly thinks that petitioners are unlikely to point out art that teaches away in their petitions. Claim construction, if you want to be heard on claim construction, you can almost view the petition and the preliminary response as a mini Markman, because in the trial institution, almost invariably the board is construing claims that it finds to be important or relevant or dispositive to the proceeding. They want to hear for references, not prior art. But I think that with respect to the falling institution rate, the points that I've put in italics are becoming more important. If, as a patent owner, you think there is a prima facie defect in a petition where a petitioner has, for example, neglected to deal with an element of an independent claim, for example, or with respect to proving up its obviousness case, if a petitioner hasn't fully developed each of the Graham v. John Deere factors for obviousness, this is the time to make that case in your patent owner preliminary response and hold the petitioner to task for meeting their burden for institution. And finally, an often overlooked argument are what we call Section 325D argument. Section 325D, you'll find it in the PGR section of the statute, but it allows the board to take into consideration when determining whether to institute a review, whether or not the office has already dealt with the same art or substantially similar art, or the same arguments or substantially similar arguments before. And if it has, the board can take that into account when instituting a trial. So on the flip side, petitioners should take heed of each of these when crafting petitions. Unless Lori has something to add to that, we'll turn it over. I'll turn it over to her, and she'll talk about Joinder.
Okay, thanks, John. So we've gotten to the point of the proceeding where the board has decided to institute trial. So at this point, for the petitioners, there's a reasonable likelihood that they are going to prevail in an IPR proceeding, for example, on the challenges that the board has instituted. At that time, the board or the rules and the statute open up a window for, again, what you may cynically refer to as piling on the petition. So it's a window where other petitioners or even the same petitioner can pile on through the process of joinder. And why is joinder important? Well, we see here it's by statute 315C provides that the director may join as a party to an inter-parties review any person who properly files a petition under Section 311 after receiving a preliminary response or the expiration of time for filing such a response determines warrants the institution of an inter-parties review. So that's a lot of language there. All it means is after one inter-parties review has been instituted, there's a period of time where the director, within their discretion, can add a party, any person. And that's critical that the statute says any person. So that could be the original filer of the petition as well as anyone else. The board in their joinder decisions make clear to point out that by statute it's discretionary. They don't have to join parties. And by their guidance, their rules are to be construed so as to ensure the just, speedy, and inexpensive resolution of a proceeding. So in the board's world, any request for joinder that could potentially slow down the trial, which seems to be the primary factor, is going to get denied. But why is joinder popular? Well, it's popular because Congress made it popular by this last sentence in 315B. And as recall, John talked about the 315 one-year statutory bar for filing. Well, you can see here that the time limit set forth in the preceding sentence shall not apply to a request for joinder under subsection C. So if someone else gets an IPR instituted on a patent and you're statutorily barred because of a complaint filed more than a year, once that institution decision gets sent out by the board, you can pile on to that existing petition and hopefully get joinder. So as you can imagine, a lot of people who are behind the bar are very interested in seeing what they can do with joinder. And we can see here by this figure how it operates. So you can join a second petition with the first petition, even if the second one is after your one-year bar. So joinder is a process that is requested by a motion. And by rule, they say that that motion has to be filed no later than 1 month after the institution date of an inter-parties review for which joinder is requested. So as you can imagine, like I said, this became a very popular tool, and a lot of parties tried to figure out the boundaries of joinder. So in the very first inter-parties review ever filed, someone tried to join that as a party without filing a petition, similar to what you may be able to do in district court. And the board said, no, we're not going to join parties. You actually have to file your petition. And coincidentally, when you file a petition, you got to file that fee with it. So you get the fee as well. So you can't file as just a party. You have to file a complete petition. Now, there's been other circumstances where the first petition is filed. And for example, if you have a joint defense group situation, one member of the joint defense group decides to file an IPR. The others don't participate in that process. But the IPR gets instituted. Well, what happens if that party settles with the patent owner and everyone else in the joint defense group is now 1 year barred? You've had circumstances where parties have tried to join a base proceeding that had been terminated by settlement, and the board said, we're not going to allow joinder, where even though there was institution, that trial was eventually terminated. So the board has shut down that strategy. Now, you can file a petition and the motion separately. There's no requirement that you file the petition and the motion separately, at the same time. So what a party could do is file their petition before the institution decision on the first case, and if institution occurs, then they can file their motion within the 1 month time frame after institution. Now, it's interesting because you see the rule that says no later than 1 month after institution date. And I think everyone who practices in front of the PTO knows how much the PTO really likes their rules and enforcing their rules. However, this is one where the board has been a little, has given parties some leeway. And so they said that, in fact, that 1 month time period can be waived if you establish special circumstances. So I guess the practice tip here is if you're outside that 1 month date and you can show good cause or good reason why you are, the board may still entertain your joinder request. Now, joinder is interesting from a procedural perspective, and how do you manage a case when the parties are joined? Well, the way the board has handled it is they've labeled the first filer as kind of the primary party of the case, and the second party is secondary or understudy. So the second party will only be permitted to file a limited number of pages where they may have disagreement. I think it's around 4 or 6 pages they're limited to. And they won't have much participation right in depositions. However, if the first chair party settles, they can step into the second chair and continue the proceeding, which is a very important benefit. So this next slide just gives you some examples of where joinder was instituted. And we won't go through all of these examples, but I think the key takeaway point here is, again, going back to the just and speedy part of the trial practice guide. And the board has pretty much followed that example. So anywhere where you've got the same parties, or even if you don't have the same parties, the key is having the same prior art, the same declarant, the same claims. That's going to get you through the door with the joinder petition. So basically all the secondary party is doing, taking the initial petition and putting their name on it. And so that will ensure joinder will occur. Anytime where you're going after different claims, that becomes a little trickier. It seems like the board decisions, or if the claims are fairly basic, for example, a dependent claim that's only adding a really well-known feature, they've tended to join because they don't see that as impacting the trial that much. But if you go for like a lot of different claims with a lot of different scope, it's unclear that the board most likely will deny joinder, as we see in the last example on that page.
Great, thanks, Lori. I'm gonna throw out one question to Lori. It's a complete surprise, but
okay.
if a joinder motion is filed with a petition, and you're still very early in the pre-institution phase, do you have to kind of provisionally oppose that joinder motion within the standard guidelines? I think it's 1 month to oppose, or do you wait until the institution decision, until you know the scope, and then oppose at that point?
Yeah, so I think in that case, probably what I would do is I would request a call with the board and ask them to strike or expunge that motion as improper, because by rule you can't file a motion for joinder until after the institution date of an inter-parties review. So if it got filed before the institution date, then I shouldn't be forced to respond to it because it's an improper motion by rule. So that would probably be the first attack I would have on that motion. If the board permits it to stand, then I'd either ask for it to be my opposition period to start running from the institution date, because if it isn't instituted, then it's moot, or I would have to respond within the opposition date. But that's probably how I would approach it.
I think that's good advice. From a petitioner, I would argue that I have a statutory right to file the joinder motion. It's not one where the board can, deny my ability to file. So I would argue, with the petition, I am permitted to file this joinder motion, and then take it from there with respect to whether, when the opposition would be due. I don't know if the board's actually ruled on this yet.
Yeah, I don't think there's been a circumstance where this would happen, but I think it would be interesting, and perhaps we can oppose each other and try it out one day.
I think some ethics rules might prevent that.
Perhaps.
Okay, so the next thing we'll discuss, and it's definitely been a hot topic of late, is the motion to amend. There is a statutory right during an inter partes review for a patent owner to file one motion to amend the patent in one or more of the following ways. You can cancel any challenged claim, or for each challenged claim you can propose a reasonable number of substitute claims. So there does exist a statutory right for a patent owner, at least in theory, to amend claims during an inter partes review, or for that matter, post-grant review, or a review of covered business method patents in these proceedings. So let's step through the next 3 or 4 slides. We'll step through the motion to amend. So the first thing to recognize, and perhaps the most important thing to recognize, is that the patent owner has a very heavy burden of proof. For the first time ever, there is a possibility for the Patent Office to allow a patent claim to issue that has not been examined. And for that reason, because again, these are adjudicatory proceedings, not examinational proceedings, for that reason, the patent owner has a heavy affirmative burden to show that it is entitled to the requested relief. Now, the basis for that burden in the rules is in Rule 4220C, which covers the general burden of proof for all motions, but it is particularly important in the context of a motion to amend. So given that this amended claim could conceivably issue and you could obtain a very valuable patent right, the logic is that because there's no examination, you have to prove that you're entitled to that claim and entitled to that relief. So we'll discuss that burden in more detail in the next couple of slides, but the other important things to keep in mind is that the motion to amend is a conditional motion. The proposed substitute claims will be directly added to the patent without examination only if the challenge claims are unpatentable, or alternatively if the patent owner can concede that those claims are unpatentable, and then only if the patent owner affirmatively demonstrates patentability of substitute claims, and that can include, if it's a question, showing that the claims are directed to patentable subject matter under Section 101. The other thing to keep in mind, and it's not on the slide, is that the limits that the Patent Office puts on motions to amend, you have 15 pages, 14-point font double space to establish that you're entitled to this relief. So it's a challenging proposition. And before we get into all of the things you need to do to show that you're entitled to this relief, I think a lot of parties are viewing these inter partes review proceedings as not being the ideal place to amend claims. So, if you're a patent owner and you think your claims are probably going to fall in view of the petition, you may want to consider alternate vehicles to pursue amendments, such as an adverse judgment followed by a reissue application, or perhaps a patent owner-initiated ex parte reexamination. But keep in mind that you cannot pursue claims of the same scope that you're relinquishing in the inter partes review. So let's turn to some of the mechanics. Under the rules, a motion to amend, you can, and again, this reflects the requirements in the statute, you can cancel a challenge claim, or propose a reasonable number of substitute claims. You cannot simply add a new claim. That's not permitted. It has to be a substitute claim for a claim that is under review. Motions to cancel claims are granted. If you have as a patent owner want to cancel a claim, the board is not going to deny your that requested relief. And one motion to amend with substitute claims has been granted to date. The United States was a party to that case, and it was an unopposed motion to amend. But to date, that is the only motion to amend that has been granted by the board. So what do you have to do? What do you have to put in your motion? So you have to include a claim listing. Although I recently participated in a panel discussion with a number of PTO judges, including Chief Judge Bolick, and he said that one suggested to the audience there that you can and perhaps should request to have your claim listing in an appendix to the motion to amend, and that if you think you need extra space pages in your motion to amend to ask. And I think this reflects a recognition by the PTAB that meeting the established burden in their 15-page limit is going to be exceedingly difficult in most instances, and it shows a willingness to perhaps relax those rules in that regard. So you have to show, in addition to listing the claims, you have to show support in the original disclosure of the patent for each claim that is added or amended, and the support in an earlier filed disclosure for each claim for which benefit of the earlier filing date is sought. So you do have to go back to the original disclosure and show support for your amendment or your substitute claim in that original disclosure. You have to provide a copy of that original disclosure and cite to it. And let's move on to showing patentability over the prior art. You need to not just show patentability over the art that's been asserted in the inter partes review. You also have to show patentability over all of the art that you're aware of and over the general state of the art at the time of invention. The lead case on this, if anybody has been practicing before the board and considered a motion to amend, the lead case on this remains the idle-free systems case, and that's cited on the slide. The 101 case where a patentee was required to show that amended claims were directed to patentable subject matter is cited on the slide. And most motions to amend, in fact all but one, have been denied because of this high hurdle of demonstrating patentability.
So John, before we move on, I'd like to put you on the hot seat for a second and
Excellent.
talk about the 101 decision. So in the Ariosa 101 decision, it seemed like a big factor was that 101 had been challenged in the district court, so that the patent owner was on notice that 101 was an issue. Do you think the Ariosa decision, which is the IPR 2012-22 and its joined case 2013-250, do you think that stands for a broader proposition that now 101 is on the table for all petitioners for motions to amend, or do you think that case is going to be limited to just the facts of that case?
So that's right. In the cited case, 101 was an issue in the co-pending enforcement action in the district court. But it wasn't raised as an issue until most of the way through briefing with respect to the motion to amend. So I think that the 101 issue was raised in between the opposition and the patent owner's reply to the opposition to the motion to amend. And even then, the board said that the patent owner in its reply should have addressed 101. I think that, so my gut feel is that certainly if 101 has been raised as an issue in the underlying enforcement action, you should address it in your petition. In your motion to amend. If all of the co-pending proceedings are silent as to 101 and your claim really doesn't fall into a gray area, then clearly I don't think you have an affirmative burden to show patentable subject matter. I think the gray area lies in, you know you're in the gray area. Do you affirmatively address it? Might be a good idea, and you maybe should ask for extra pages to do so, to be on the safe side.
I think that also is a practice tip for those of us who also practice in the district court, when you're doing your invalidity contention in front of the district court, if there's an IPR in the wings, to make sure you fully develop your 101 case early on, so that even if that case gets stayed, the patent owner is on notice that 101 could be an issue, and you have it in your back pocket if a motion to amend hits you during trial. So just another factor when you're dealing with these two worlds of district court and IPR that you've got to keep on top of. Okay. So the next topic is discovery, and the rules permit a couple types of discovery. There's routine discovery and additional discovery. And routine discovery really is incredibly limited. It's just if you serve a petition, you've got to also give copies of the prior art you're relying on. And there's also a rule about if the party knows of any information that contradicts the position that they're taking, that they're required to serve that on the other party. And you can imagine how little that rule gets used in practice. So the question is additional discovery. And there's a few hot areas of additional discovery in these trials. Particularly, a lot of the additional discovery focuses on two points. The first is real party and interest. And as we discussed early on, we've got some of these bars that are triggered by not just the filer or the petitioner, also any real party and interest of the petitioner. Then when you get to the conclusion of the trial, if the petitioner is not successful, the petitioner and their real party and interest, et cetera, will have estoppels attached. So it's really important to understand the real party and interest, because that could implicate whether the petition can move forward or perhaps limit what can be presented at trial. So a lot of the additional discovery requests have been by patent owners trying to get behind who is actually behind the filing. Is it just the petitioner, or is there a group of other parties behind it? The other area, which has always been a complication in front of the PTO, and I know Jon has had quite a lot of experience on this in the re-exam world, is secondary considerations of non-obviousness. And as a patent owner, it's very challenging and almost impossible to get secondary evidence that's not under your control through a PTO proceeding. And re-exam, I think it was really not possible. And in these IPRs and CBMs, you have the ability to request additional discovery. So a lot of parties have done so to try and get secondary consideration evidence. Now, for IPRs, the standard is quite high. You have to show that it's the interest of justice why you need this additional discovery. And for CBMs and PGR, you just have to have good cause. So early on, the Patent Office established 5 factors that you have to address when you're requesting additional discovery. And we'll go through these pretty quickly. The first factor is a lot of decisions are based on this, where you have to have something more than a possibility or a mere allegation. So you have to have something, show the Patent Office that there's something there more than speculation. So under the interest of justice standard, the requesting party should already be in possession of evidence tending to show beyond speculation that, in fact, something useful will be uncovered through the additional discovery request. And that is, in some circumstances, very hard, particularly when you're talking about real party and interest and secondary consideration. So you've got to show some evidence that, for example, a relationship exists that could be a real party and interest relationship, but you can't really show that without getting the additional discovery. So it puts the patent owner in a bit of a catch-22 in these circumstances. The second factor is litigation position. So the board has early on said, if it looks like your additional discovery is you're trying to get to the other side's litigation positions through the IPR, we're going to shut that down right away. This is not an avenue for any discovery you can want. It's got to be very targeted and directed to this proceeding. Can you flip me to the next slide? The third factor is, and again, going to kind of be an inexpensive aspect that the board is going for. If you have the ability to generate equivalent information by other means, they're not going to give it to you. For example, if you want a file history and you could have gone to a service to get it, they're not going to make the other side hand over that file wrapper because you could have gotten it through a service. Now, if the file wrapper is not publicly available, then there's been a case where they've let that discovery go through. Your instructions have to be easily understandable. For example, if you're going to ask for interrogatories, the interrogatories have to be understandable and easy for the other side to answer. And the fifth factor is the request can't be overly burdensome. So again, what the board is trying to do is be very clear that this is not going to be like district court discovery. It's very narrow. We're not going to force a side to get into expensive discovery. So the message is, if you come to us, know what you want, have reasons why you should get it, and make sure you're very narrowly tailored in your request. So here's some examples of where additional discovery has been granted and denied. So you see a lot of these, again, are real party and interest related and some secondary considerations. So in the first case, the patent owner tried to ask for some interrogatories to get at who the real party and interest behind the petitions were. The board found that their interrogatories were not focused and they went beyond just trying to figure out issues related to the filing. Now, in a CBM, which is a lower standard, the board allowed discovery of the documents and things considered by the expert in preparing the declaration. So that's one thing you can ask for if it hasn't been provided. Now, the next item relates to secondary considerations. The patent owner wanted information about the other side's product and sales information to establish, copying and some of the other secondary indicia. And the board said, no, you can't have that through the IPR, which really limited their ability to establish secondary considerations. Then we see a couple more RPI, real party and interest cases, where the petitioner is trying to get an indemnification agreement. And they denied, or they granted it where the patent owner had evidence that established the existence of a dispute over indemnification. Therefore, they were allowed to get additional communications between the parties to try and establish control necessary for real party and interest. But you can see in another case it was denied because there wasn't enough evidence to establish that there was an involvement. So there's a number of other cases, but you can see they all fall along the same line. For an IPR, you have to have evidence more than mere speculation, or you're not going to get through the door.
So my take on this before we move to depositions is that this first factor, and they're often called the Garmin factors because that's the case where the board set forth these 5 factors. That first factor is particularly onerous, where the information sought is typically lies within the exclusive control of the other party. And as Lori mentioned, that the 2 most obvious circumstances there are secondary considerations of non-obvious, such as copying or attempts to arrive at a solution, or failed attempts to arrive at a solution, and the real party and interest issues. And I think the board recognizes that that factor is killing discovery requests where there actually might be information, material to the patentability question sitting out there. And I think that maybe sometime in the not-so-distant future, if a patent owner can craft a rifle shot, not a shotgun blast, but a rifle shot request that is particularized enough and not overly burdensome for the party to produce, that such a request might be able to overcome this first discovery factor.
Okay, so the next topic related to discovery is depositions, and we won't spend a lot of time on this, but there's been a lot of press in both the district court realm and the PTAB realm about deposition etiquette. And I think the takeaway here is it seems like what the board wants is a dialogue between the attorney and the expert, and they don't want that dialogue to be hindered by excessive unnecessary objections. And in a recent decision that came down, I think this week, the PTAB granted 7 additional hours of deposition because they felt that the objections being made by the defending attorney were dilatory and improper, and in some cases seemed to be counseling the witness on how to answer. And why is this important? Because in the PTAB world, not only do you have to pay for the additional expert time, the producing party pays for the deposition. So, and it flip-flops from district court. So that's an additional expense now by the party who is defending. So other than that, like very different quirky things, like there's no errata. The issue of errata sheets like you have in district court litigation, the PTO doesn't want to see them. If you want to file one, you have to ask for authorization, and you most likely you're going to be denied. So just a slightly different approach to depositions in the PTAB world than district court.
Great. I'll add one thing to that recent case that came down just the other day. An additional reason for the 7 extra hours of deposition was that there were 2 declarations from the same expert that apparently each spanned over 300 pages. If you, as a person putting forth a declaration, think that you need multiple declarations, or that you need declarations that total 600 pages in length, you ought to be prepared right there for the board to grant additional time for the deposition beyond the 7 hours. So just again, the board is looking to enforce etiquette and reasonableness in these depositions, and not cross-examination depositions, and not let them get out of hand. So moving on to, in the discovery vein, to motions to exclude. Over the course of a trial, parties have pretty tight deadlines for serving, not filing with the board, but serving any objections to evidence on your opposing counsel. At trial initiation, there's a 10-day window for serving objections to evidence, and thereafter, for any substantive paper that has evidence along with it, you have a 5 business day window to serve objections. And then at the very end of the trial, in the scheduling order, there's a window for parties to file motions to exclude. As a basis for that, before you can even file the motion, you need to have timely served your objections along the way. So some things to keep in mind when you're considering whether to file a motion to exclude. First, a motion to exclude is not an appropriate vehicle for challenging the scope of a reply or supporting evidence. Motions to exclude instead need to go to the admissibility of the testimony or the evidence, and not the weight. So the board views it as improper to try and leverage a motion to exclude as a sideways attack on, for example, the credibility of a witness, or a sideways attack on the weight of evidence. Rather, it should be, remember that the federal rules of evidence apply to these proceedings, so you should have a hook there for the admissibility of the evidence before you file a motion to exclude, or at least a proper motion to exclude. Often, the board, more often than not, denies motions to exclude or says that they are moot. The reasons for saying that they're moot, a party can agree or concede that they will not rely on the evidence just to avoid a dispute, or, and this is often the case, the board will just say, we haven't relied on that evidence, so we don't need to consider the motion to exclude. There's one interesting case out there where the motion was granted. Lori's a little more familiar with that case than I am, so I'll let her describe it.
Yeah, so this case related to some documents containing lab-generated data, and the challenge was that those documents were hearsay and not subject to a business record exception. And the board agreed with the party filing the motion to exclude and did exclude those documents. But interestingly enough, they allowed in the expert declaration that relied on them because they said the expert could rely on them. So it was kind of a win-lose for the party challenging it. I will say, related to motions to exclude, it kind of brings in the notion of a motion to strike, which is the first point. And I think one of the most frustrating things as a practitioner right now is what avenues are available for you when a party on the other side clearly goes beyond what they're permitted to do in a responsive paper. And the board just recently in a decision in one of my cases came out and said that we are permitted to raise it at oral argument that where that party had gone beyond, and that the board can figure it out on their own, which kind of puts parties in a bit of a bad position, because now you have to deal with issues that you may not have an opportunity to respond to because your briefing has been completed. So that's another, I think, hot topic that's going to be more and more explored in the next year.
I agree. One other observation I'll make there is that before you file a motion to strike because you think a party has done something outside the scope of what they're permitted to do, you obviously have to request a conference call with the board. And I think the act of asking for that conference and the act of explaining to the board what has happened can sometimes be valuable, even though ultimately the board says, well, we're capable of figuring that out on our own, we're not going to authorize the motion. At least you have a vehicle for raising that issue, putting it on the board's radar screen, and not, thinking that relying on the board to figure it out themselves. Do you agree with that?
Yeah, no, I think that's critically important, because you can also have a reporter on the call to have a transcript that you can use, and also as part of that call, the board, in my case, issued an order where they permitted me to argue it at the oral hearing, whereas if I wouldn't have raised it and asked for that relief, even though I wasn't allowed to file a motion, there would be an argument that I couldn't raise it at oral hearing. So it's important to, again, protect your rights, because you also have to think with a view towards appeal as well.
So we're down to our last two slides. They deal with live testimony and settlement and termination. I think we'll go through these pretty quickly. Lori's going to talk about the live testimony and the one instance where it was allowed, and then I'll cover settlement and termination, and we'll end with just looking at final written decision statistics.
Okay. So real quickly, I think the lesson learned on this live testimony where it was granted is be careful what you ask for. In this case, the board has been hesitant to allow live testimony. They granted it in this case for a few very specific reasons. One, that the witness that was testifying was a fact witness. The board was very clear that we're not going to allow expert witnesses to testify at oral hearing unless there's a really compelling reason. They said, fact witness, yes, expert, we can tell in the papers. The fact witness in this case was dispositive to the case. So the credibility was incredibly important of that witness. And again, it was limited to cross-examination and redirect. And why I say be careful what you wish for, in district court, when you put a witness up, you have the two sides asking questions. Well, when you have a witness in front of the board, the panel asks questions, which is what happened in this case. The panel members were peppering the witness with some very detailed questions. And in the end, I believe the panel found that the witness's testimony was incredible, right? So again, you have to be very careful when you want to put a witness up in a live testimony situation, and beware that the board will be able to ask any questions. They're not limited necessarily to papers on the record. And so, you have to also then prepare your witness in a different way than you may prepare them for trial.
Great, thanks, Lori. So on to our last substantive topic, which is settlement and termination. For IPRs, and there's analogous sections in the statute for PGR, Section 35 U.S.C. Section 317, where there is a settlement between the parties, sets forth the ability of the board to terminate a proceeding as to a petitioner upon a joint motion, and gives the board the discretion to terminate proceedings in their totality where parties have settled and there is a joint motion to terminate. Now, on its face, Section 317 applies only to instituted proceedings, but there have been at least 7 cases that we're aware of where in the pre-institution phase, parties have reached settlement, have requested termination of the proceeding, and proceedings have been terminated. Now, one of the requirements to terminate a proceeding or to file a joint motion to terminate is that any underlying settlement agreements must be in writing and must be filed with the board. And even though Section 317 doesn't apply on its face, the board is still applying that statutory provision and the rule that enforces it, Rule 42.74, and even for pre-institution, they're requiring settlement agreements, if they exist, to be filed. So post-institution, the board is very strict in applying Section 317. Settlement agreements have to be in writing. They have to be filed with the board in full, and any collateral agreements that are referred to in the agreement that you're filing, they all have to be provided. It's not permitted that you redact portions of the settlement agreement. The whole thing has to go in. Keep in mind that you can request that the settlement agreement be kept separate from the file as business confidential information, and the board will grant those requests. And at that point, the settlement agreement is available only to federal government agencies upon request or to third parties upon request for the showing of good cause. It's our belief that the board wants to encourage settlement and that it will guard that good cause provision very, very closely. Keep in mind, very important, the board is not a party to the settlement and can, at its discretion, maintain an instituted proceeding against the patent owner. So in that regard, the earlier that you get your settlement done and request joint termination, the better. Preferably before the substantive record is complete. If you can get it done before that, you have a much better chance at getting full termination. There is at least one case where the parties secured full termination on the eve of oral hearing, and that's cited on the slide. But again, the board has also continued proceedings against a patent owner despite settlement, and we have two other citations on the slide for that. The final thing I'll mention that the board takes into account, it will take into account the status of the any underlying co-pending enforcement actions, whether or not there are additional defendants that are not parties to the proceeding. It wants to have the full view of what's going on with that patent before, so it can make a fully informed decision on whether to continue a proceeding or end a proceeding in its entirety. So the board invariably asks for a full status of the underlying patent with respect to other actions. So that comes close to ending the substantive portion of our presentation. I'll turn it over to Lori, where we'll review our final written decision statistics that we track here at the firm.
Okay. And so we'll just quickly go through this slide because I think we're about 5 minutes over right now. This slide just gives you a sense of where the final written decisions have come out. And as we can see, the percentage of final written decisions received, there's been about 60% received. And I think the more interesting statistics are what we see here at the bottom, where they're separated into the challenge claims that were canceled. So this is looking at from the petition through final written decision, how many challenge claims have been canceled completely. And we see here only 16 cases where none of the challenge claims have been canceled. So the rest, the patent has had either some or all of their challenge claims canceled. Now, for institution, we can see that, again, we have the 16 where none were canceled, but we've got more where all the claims that were instituted on were canceled. And we see the CBM statistics are a little more
narrowing.
Yeah. So in CBMs, if you get institution, there's almost a 100% chance that your claim is going to end up canceled. So having a CBM instituted is it's very difficult if you're the patent owner from the statistics that we've seen to date. So I think with that, that ends our presentation for today. I want to thank everybody for attending. And if you have any questions, don't hesitate to send